Decentralization, local autonomy. Limbana v Mang Ellen. Facts. Sultan Alimbuzar Limbana was appointed as a member of the Sangguniang Pampuk, Regional Autonomous Government, Region 12, representing Lanao Dal Sur. He was then elected Speaker of the Regional Legislative Assembly of Central Mindanao, composed of 18 members. Later, Congressman Datu Guimad Matalam, Chairman of the Committee on Muslim Affairs of the House of Representatives, invited Mr. Xavier Razal, Pampuk Speaker of Region 11, Samboanga City and the petitioner in his capacity as Speaker of the Assembly, Region 12, in a conference. Petitioner then ordered Acting Secretary Alimbuyeo to inform the Assemblyman that there will be no session on said date as petitioner and Razal are attending the House Committee hearing. The Assembly held session in defiance of petitioner's advice. After declaring the presence of a quorum, the Speaker pro tempore was authorized to preside in the session. On motion to declare the seat of the Speaker vacant, all Assemblymen in attendance voted in the affirmative, hence, the Chair declared said seat of the Speaker vacant. The petitioner then went to court praying that judgment be rendered declaring the proceedings held by respondents during the session as null and void and holding the election of petitioner as Speaker of said Legislative Assembly or Batasan Pampuk, Region 12 held on March 12, 1987 valid and subsisting, and making the injunction permanent. Issue 1. The expulsion of the petitioner has made the case moot and academic. Ratio. We do not agree that the case has been rendered moot and academic by reason simply of the expulsion resolution so issued. 4. If the petitioner's expulsion was done purposely to make this petition moot and academic, and to preempt the court, it will not make it academic. On the ground of the immutable principle of due process alone, we hold that the expulsion in question is of no force and effect. In the first place, there is no showing that the Sangguniang had conducted an investigation, and whether or not the petitioner had been heard in his defense, assuming that there was an investigation, or otherwise given the opportunity to do so. What appears in the records is an admission by the Assembly that since November 1987 up to this writing, the petitioner has not set foot at the Sangguniang Pampuk. To be sure, respondents aver that he Assemblyman, in a conciliatory gesture, wanted him to come to Cotabato City, but that was so that their differences could be threshed out and settled. Certainly, that avowed wanting or desire to thresh out and settle, no matter how conciliatory it may be, cannot be a substitute for the notice and hearing contemplated by law. In the second place, the resolution appears strongly to be a bare act of vendetta by the other Assemblymen against the petitioner arising from what the former perceived to be obduracy on the part of the latter. Indeed, it speaks of a case before the Supreme Court on question which should have been resolved within the confines of the Assembly, an act which some members claimed unnecessarily and unduly assails their integrity and character as representative of the people. An act that cannot possibly justify expulsion. Access to judicial remedies is guaranteed by the Constitution, and, unless the recourse amounts to malicious prosecution, no one may be punished for seeking redress in the courts. We therefore order reinstatement, with the caution that should the past acts of the petitioner indeed warrant his removal, the Assembly is enjoined, should it still be so minded, to commence proper proceedings therefore in line with the most elementary requirements of due process. And while it is within the discretion of the members of the Sangguniang to punish their erring colleagues, their acts are nonetheless subject to the moderating hand of this court in the event that such discretion is exercised with grave abuse. Issue: what is the extent of self-government given to the two autonomous governments of Region 9 and 12? Ratio: the autonomous governments of Mindanao were organized in Regions 9 and 12 by Presidential Decree No. 1618. Among other things, the decree established internal autonomy in the two regions within the framework of the national sovereignty and territorial integrity of the Republic of the Philippines and its constitution. with legislative and executive machinery to exercise the powers and responsibilities specified therein. It requires the autonomous regional governments to undertake all internal administrative matters for the respective regions, except to act on matters which are within the jurisdiction and competence of the national government, which include, but are not limited to, the following: 1. National defense and security, 2. Foreign relations, 3. Foreign trade, 4. Currency, monetary affairs, foreign exchange, banking, and quasi-banking, and external borrowing. 5. Disposition, exploration, development, exploitation, or utilization of all natural resources, 6. Air and sea transport, 7. Postal matters and telecommunications, 8. Customs and quarantine, 9. Immigration and deportation, 10. Citizenship and naturalization, 11. National economic, social, and educational planning, and 12. General auditing. In relation to the central government, it provides that he president shall have the power of general supervision and control over the autonomous regions. Now, autonomy is either decentralization of administration or decentralization of power. There is decentralization of administration when the central government delegates administrative powers to political subdivisions in order to broaden the base of government power and in the process to make local governments more responsive and accountable, and ensure their fullest development as self-reliant communities and make them more effective partners in the pursuit of national development and social progress. At the same time, it relieves the central government of the burden of managing local affairs and enables it to concentrate on national concerns. The president exercises general supervision over them, but only to ensure that local affairs are administered according to law. He has no control over their acts in the sense that he can substitute their judgments with his own. Decentralization of power, on the other hand, involves an abdication of political power in the favor of local governments units declared to be autonomous. In that case, the autonomous government is free to chart its own destiny and shape its future with minimum intervention from central authorities. According to a constitutional author, decentralization of power amounts to self-immolation, since in that event, the autonomous government becomes accountable not to the central authorities but to its constituency. But the question of whether or not the grant of autonomy to Muslim Mindanao under the 1987 Constitution involves, truly, an effort to decentralize power rather than mere administration is a question foreign to this petition, since what is involved herein is a local government unit constituted prior to the ratification of the present Constitution. Hence, the court will not resolve that controversy now, in this case, since no controversy in fact exists. We will resolve it at the proper time and in the proper case. Under the 1987 Constitution, local government units enjoy autonomy in these two senses. An autonomous government that enjoys autonomy of the latter category is subject alone to the decree of the Organic Act creating it and accepted principles on the effects and limits of autonomy. On the other hand, an autonomous government of the former class is, as we noted, under the supervision of the national government acting through the president. If the Sangguniang Pampuk, then, is autonomous in the latter sense, its acts are, debatably, beyond the domain of this court in perhaps the same way that the internal acts, say, of the Congress of the Philippines are beyond our jurisdiction. But if it is autonomous in the former category only, it comes unarguably under our jurisdiction. An examination of the very presidential decree creating the autonomous governments of Mindanao persuades us that they were never meant to exercise autonomy in the second sense, that is, in which the central government commits an act of self-immolation. Presidential Decree number 1618, in the first place, mandates that he president shall have the power of general supervision and control over autonomous regions. 33, the second place the Sangguniang Pampuk. Their legislative arm, is made to discharge chiefly administrative services. Hence, we assume jurisdiction. and if we can make an inquiry in the validity of the expulsion in question, with more reason can we review the petitioner's removal as Speaker.